Disney is still beating the dead horse of "you violated my First Amendment rights, state of Florida." Well, of course, we've chronicled why that is not accurate all this time, but Disney still seems to persist. And here we have, in the latest filing with the federal court, Disney is saying that its battle with Ron DeSantis touches every company. Quote, "If the line is not drawn here, there's no line at all." The problem, of course, is this is all based on a logical fallacy, a completely false argument. And we're going to remind folks why. Renegade Online. Well, folks, welcome back. Another great day here at Valliant Renegade. It's good to see everybody out there once again. And if you are like one of the many folks watching this video, not yet subscribed to this channel, please take a moment and turn that little red subscribe button to gray. Hit that like button, hit that notification bell, share this sucker out on the social medias, and of course, please do leave a comment before you head out the door today. Make sure to join us every Sunday afternoon at 6 p.m. Eastern for the live show. So Disney has broken out yet another cry me a river of tears moment here in federal court, whining and complaining that after their very lengthy, multiple complaints, sophisticated, supposedly legal argument has now basically been whittled down to one complaint in federal court, after Disney decided to strike the rest of its arguments and just leave the "they violated my First Amendment rights, y'all." As reported by Fortune magazine and many others, if Florida Governor Ron DeSantis wins a federal lawsuit in which Disney claims its free speech rights were violated by the Republican leader, the company won't be the last entity to be punished over supporting, quote, "a disfavored viewpoint," Disney said in court papers on Monday. The First Amendment protects the right of free speech even if it goes against government powers, Disney said in court documents, asking a judge to reject DeSantis' motion to dismiss Disney's First Amendment lawsuit in Tallahassee federal court. Well, of course, the First Amendment protects individuals and private companies from government reprisal, but is that actually the case here? You see, in order for this case to fly, that means that the state of Florida would have had to take direct punitive action against the Walt Disney Company itself for going against politics in Florida. The lawsuit says DeSantis unconstitutionally revamped and took over Walt Disney World's governing district in retaliation after Disney publicly opposed a state law banning classroom lessons on sexual orientation and gender identity in early grades. The law was championed by DeSantis, and quite frankly, about 80% of the voters in Florida supported it, who currently is running for the 2024 GOP presidential nomination. Unconstitutionally took over and revamped the Walt Disney Company's governing tax district? Wait. Hang on a second. There's the problem with this argument that we have been bringing to people's attention for the last year and a half since this whole mess started. And that is that no private company, including the Walt Disney Company, is entitled to have its own private government. What was done in 1967 to form the Reedy Creek Improvement District was essentially a gift, a privilege that was extended by the people of Florida via their duly elected representatives in the Florida state legislature to the Walt Disney Company. And that came with some strings attached. And of course, since then, Disney has not really held up their end of the bargain. That privilege bestowed by the legislature is still under the control of the state of Florida. It's the state of Florida who creates special taxing districts, not the Walt Disney Company. And the Walt Disney Company does not own Reedy Creek, nor has it ever. So then how then do you conflate action taken to reform a special taxing district that was created and can also be destroyed as a privilege by the people of Florida and the state legislature with being a wholly owned subsidiary of the Walt Disney Company? It isn't. Disney opines to the court that, quote, "if the line is not drawn here, there is no line at all," Disney said Monday. The retaliation against Disney for crossing the governor's line was swift and severe. For the explicitly stated purpose of punishing Disney for its comments, the state immediately stripped Disney of its voting rights in the governing body that oversees Disney's use of its own private property. And therein lies yet another problem with Disney's argument. You see, when the Reedy Creek Improvement District was formed in 1967, one of the things that Walt himself was gearing towards with that special taxing district, the reason the state of Florida granted this privilege to the Walt Disney Company, not a right, but a privilege, was because Walt had envisioned creating a city of tomorrow, an actual residential community that would be built around the Magic Kingdom, let's say, full of neighborhoods, stores, a thriving economy, a city, a town, an actual community. Of course, Walt died a few months after this, and then the legislature granted the privilege still to the Walt Disney Company. After which, Walt Disney did build the experimental city of tomorrow, but it was Epcot. It was a theme park. It wasn't an actual community. It wasn't a city or a town. It wasn't going to have actual independent voters that would vote for the leadership of the special taxing district. No, Disney actually did a 180. They reneged on Walt's promise after he died and decided to not build a residential community, and instead basically built 2 cul-de-sacs, each with about a dozen different double-wide trailers as they stand now, and they called those cities. Now, of course, every resident of those properties is put there, hand-selected by the Walt Disney Company to make sure that Reedy Creek would do what Disney wanted. In other words, Disney spent the last several decades abusing the privilege the state of Florida had bestowed upon them. And for many years before 2021 and 2022, the state of Florida had been looking back at that as one of the biggest mistakes they had ever made. And finally, they had the political willpower to rein the Reedy Creek Improvement District in and put it in line with the other 1,900 special taxing districts in the state of Florida that had to play by an entirely different set of Florida statutes than the Walt Disney Company did, at least insofar as Reedy Creek. Ron DeSantis and other defendants, including a state agency and the DeSantis appointees on the board of the revamped district, now called the Central Florida Tourism Oversight District, say the First Amendment lawsuit is meritless and that they are immune from liability. And as we've already pointed out, of course, this is true because, again, the Walt Disney Company has no right to its own private government. No corporate entity does. And the Reedy Creek Improvement District is not a wholly owned corporate subsidiary of the Walt Disney Company. It is a totally separate thing. Disney's argument in federal court is literally that Florida took away a special taxing district that Florida had the right to take away, and somehow that's an impact on our First Amendment rights. Before control of the district changed hands from Disney allies to DeSantis appointees, don't you like how the article actually admits they were all Disney allies? The Disney supporters on its board signed agreements with Disney, shifting control over design and construction at Walt Disney World to the company and prohibiting the district from using the likenesses of Disney characters on other intellectual property without Disney's permission. The new DeSantis appointees claimed the 11th hour deals neutered their powers, and the district sued the company in state court to have the contracts voided. Now, while the government entity would have no right to utilize the likenesses of Disney's intellectual property, Disney also had no right to go ahead and usurp government authority into corporate hands. That is an absolutely ridiculous thing to even try and do. But of course, Disney figured, why not? We've got nothing else. The governmental powers of the Reedy Creek Improvement District that was granted by the state of Florida had no right to be turned over to a private corporate entity to begin with, whether they had a contract or not. There is no state in the union that would actually declare this to be legal and valid. That would mean that any special taxing district, not only anywhere in the state of Florida, but how about anywhere in the United States, could suddenly enter into a deal with, say, Apple or Google or Facebook or any other major company out there to just unilaterally turn its powers, its governmental powers, over to a private entity. A simple example is this. Let's say you walk into an Enterprise rent-a-car. You rent your Toyota Camry, you drive off the lot, and then right down the street to Jimmy's Used Cars. You then tell Jimmy, hey, I want to sell you this Toyota Camry. Jimmy hands you $10,000 cash. You hand Jimmy the car and you walk away. Well, of course, Enterprise is going to come back and say, wait a minute, You had no right to sell that car. And you say, well, too bad. I have a bill of sale and Jimmy has got the car. That will never stand up in court. You can't sell property that you don't own, and you can't give away rights and privileges and governmental powers that you don't actually own. So whether there's a contract or not between the old Reedy Creek and the Walt Disney Company doesn't matter a hill of beans. There is no amount of whining and complaining from the Walt Disney Company that is going to turn this in their favor, not under the guise of the rule of law. Sure, could they try to find some crazy judge that actually wants to stick their neck out on this chopping block? Because that's exactly what a federal judge or a state judge would be doing. You'd be opening the door and setting a precedent for one of the most ridiculous things probably in American legal history. And that is to suggest that a private government is some inherent right of an individual or a corporate entity, or that a corporate entity could enter into an agreement with a government to take their powers away from what is supposed to be a voting public. But of course, that's the rub, because there never was a voting public in Reedy Creek. There were only the stooges that Disney put there to make sure they did Disney's bidding. You don't get to abuse a special privilege for over 5 decades and then whine when it gets taken from you. Make sure you're subscribed to Valliant Renegade and join us every Sunday at 6 p.m. Eastern for the live show.